who is actually going to be reviewing all of your documents, reviewing your schedules and your petition very carefully. He's going to assess, he or she is going to assess your financial affairs, and this is the individual that's actually going to take your assets, sell them, liquidate them is what it's called, create a pool of money if there are assets that can be that don't have equity or do have equity, excuse me, and or could not be exempted. They'll create a pool of money and they'll pay off your creditors in a Chapter 7. In a Chapter 13, the trustee is the individual who's going to monitor your repayment plan when you repay all of your creditors under the Chapter 13 plan. The bottom line is he's looking to benefit the creditors as much as possible. But by no means is the trustee an adversarial figure. He's just there to be fair and to make sure that things are happening in a fair manner. Now, once you file bankruptcy, you do have a mandatory meeting that you have to attend. It's actually in a hearing, a 341 meeting of the creditors is what they call it. It is set up as a hearing in the sense that you are placed under oath, and it's an opportunity for the trustee to ask the debtor questions and to examine you. In addition to that, the creditors of your bankruptcy estate can actually attend and ask you questions too. Typically, it's over in 10-15 minutes, and it's usually a simple process. But I wanted to make sure that you understand this is a mandatory hearing that you have to attend, and the trustee will ask you about your intentions with respect to your assets and any of your debts that you have listed in your bankruptcy schedules. The timing of the 341 meeting of the creditors typically happens about 30 to 40 days after you file bankruptcy, so that's what you can expect. Now, there are several trustees in the city of Las Vegas and up in Reno that actually are involved with the bankruptcy filings, and so they may vary in their requirements of whether they're looking for you. But generally speaking, and again, I'm on page 13 and 14 now, but generally they have a Trustees Questionnaire that you'll have to fill out, and we do provide an example in the manual on the form section of that Trustee Questionnaire. And it is a little bit detailed, but nothing that's too out of the ordinary with respect to your finances. The trustees will also typically ask for your last 2 years of tax returns. Now, they can ask for more, some do. We typically request 4 years of tax returns from our debtors just to make sure that we are prepared. If for some reason you don't have all 4 years of your tax returns, that's okay. We provided a Form 4506 in your forms manual. You would submit that form to the IRS. That's the form that you use to request the IRS give you copies of your tax transcripts or records. Or they may just give you a letter if you didn't have to file taxes for whatever reasons. They'll give you a letter indicating that you did not have to file taxes, and that will be sufficient to satisfy the trustee's needs. In addition to that, the trustees typically request at least 6 months of your previous financial statements. When I say previous, I mean previous to filing. They're going to want 6 months up to the date that you filed. Financial statements such as checking, savings accounts, any investment accounts, or anything like that. And last, the trustees ask for your last 6 months proof of income and your expenses. Again, they're just doing an overview of your financial circumstances. So typically you would provide these documents 10 to 14 days prior to your 341 meeting. Most of these documents you will get back. But just in case, we recommend that you give copies and not your originals in the event that you do not get the documents back. Okay, page 14, financial counseling requirements. After the 2005 revision of the Bankruptcy Code, there are some new requirements involved with filing bankruptcy. The first one is before you actually file bankruptcy, you have to attend a financial course. You have to do this within 180 days prior to filing, and you do file what's called a certificate of compliance, that you have complied with the request of the Bankruptcy Code, and that is attending this course. And we do give you some examples of, examples of where you can go to get the certificate. Consumer Credit Counseling Services here in Las Vegas, for instance. You can also obtain that online or by telephone. In addition to that, you have a post-bankruptcy filing requirement, which is another financial counseling class, and you will receive a certificate of completion after the bankruptcy filing. This must be filed with the court at least 45 days from the first date set for your 341 meeting. So what happens is you'll have a date set for your 341 meeting, and you need to file that certificate of completion within 45 days of that date. Or, that's a Chapter 7 specifically, by the way. If it's a Chapter 13, you're obligated to file the certificate of completion before your debts are discharged in your Chapter 13 case. And we're going to talk about Chapter 13 in a few minutes. Okay. One of the things we hope that you can assess after attending today's class is, am I going to file a Chapter 13 or am I going to file a Chapter 7? Well, since 2005, we don't necessarily have the choice anymore. They've given us some restrictions, and we're going to talk about that right now. For instance, you don't have a choice, and it's based on typically your income, your gross income for the year. And you'll note on page 15, we've given you some information about the median income. What that means is what's the average income for households in the state of Nevada. Now, every state has a median income, and we're providing you here Nevada's. For a family of one, it's $48,194, and it's approximately $6,900 for every dependent thereafter. You'll see family of two up to family of four that we provided, and then, of course, we provided you in the form section the chart identifying all of the states as well as the number of dependents. You can look at that later. If you are above the median income, you have to satisfy what is called a means test. Now, this is a mathematical calculation that is done where essentially you're taking your gross income, deducting your expenses, and you have what's left over is called disposable income. If the disposable income is approximately $166, give or take, per month left over at the end of the month, in other words, you take your income and you deduct all of your expenses. If it's $166 left over at the end of the month, then guess what? You have to file a Chapter 13. There are some exceptions, but this is the rule of thumb that we usually follow, and just be mindful of that. One point I failed to make earlier, that if your income automatically falls below the median, you don't have to mess with the means test. You are allowed to file a Chapter 7. It's only if you're trying to file a Chapter 7, but your income is above the median amount, that you have to satisfy the means test. This is one example where typically we recommend that you'd want to seek attorney assistance in deciding which bankruptcy you're going to file. Now, if you're going to file a Chapter 13 and you know you're going to file a Chapter 13, it's voluntary. You can do it and you don't have to worry about the means test necessarily. Now, under Chapter 13, that is a debt reorganization as opposed to Chapter 7, which is a liquidation of assets. Now, the filing fee for Chapter 13 is $274, and typically it's a repayment plan where you partially or fully repay all of your debt. Now, it's a 3-year plan or a 5-year plan in most instances, and that again is based upon your median income. If you fall below the median income, you're in a 3-year plan. If you fall above the median income, you're in a 5-year plan. Now again, the trustee will monitor the payments that you send to the trustee, and he will distribute that payment to your various creditors. Any of your secured creditors, such as your car payment or your home, are typically paid outside of the plan. So on a monthly basis, you'd be paying your payments directly to your secured creditors and then a second payment to your trustee. Now, be mindful that car payments can and are often included in the repayment plan for various reasons, and you would want to talk with your attorney about those details as to whether that's better for you or not. Benefit of a Chapter 13 plan is that you can actually pay your arrearages on a mortgage in the actual plan, as well as domestic support order obligations, attorney's fees, trustee's fees. All of those will be calculated in your repayment plan. Now, we've listed on page 15 and 16 the pros and cons of Chapter 13. We're just going to go over those real brief. In a 13, you get to keep most or all of your property, but maybe a con to that is you're going to have required visits to the court on multiple occasions, as opposed with the Chapter 7, it's just one time. Another pro to Chapter 13 is you get to pay off all of your back taxes, reduce or negotiate interest rates on a vehicle per se. You also will pay your home arrearages, like I mentioned earlier, while maintaining your normal payment to your creditor on a home, and you'll pay off your debts with a fresh start in 3 to 5 years. Some other cons to filing Chapter 13 include it's a very strict budget that you are going to be put on based on the limitations of your disposable income, and most of your payment that's left over at the end of the month is going to be paid into that repayment plan. Unfortunately, only about 30%